Stan in San Francisco. Hey, Stan, what's on your mind today?
Hi, Tom. You know, as an independent person, if I were to set up an offshore bank account to avoid taxes, I'd probably be prosecuted and going to jail. Why is it that corporations are now considered persons and can do that legally? I just don't understand how they can have their cake and eat it too.
It all starts in 1774 after the Civil War when the states ratified the 13th, 14th, and 15th Amendments of the Constitution to strip slavery out of the Constitution. At that point in time, and even today, but for the last 300 years in common law, there are two kinds of persons. There are natural persons like you and me, this is as legal terms, and then there are artificial persons, and those are corporations, churches, unions, anything that has to have some sort of legal person status so that it can sue and be sued, it can go to court, it can be held accountable, it can pay taxes, things like that. And so in 1774, when Congress ratified, or three-fourths of the state ratified the 14th Amendment, which says no person shall be denied equal protection under the law, which was Congress's way of saying that you can't refuse to give an African American equal process under the law. In other words, due process is extended to everyone. They didn't say no natural person. They simply said no person. So in 1886, the Southern Pacific Railroad, there were actually 5 of these tax cases that went before Stephen Field. He was back in that day. Every member of the Supreme Court, the 9 members of the Supreme Court, were also the justices for the circuit courts. So 9 months out of the year, they were the circuit court judges. And then 3 months out of the year, they were in Washington, D.C., and they all got together as the Supreme Court. And Stephen Fields was on the Supreme Court, and he was also the guy who was at the Ninth Circuit, which was the West Coast. And he had a bunch of these cases. There were 6 of them that made their way to the Supreme Court. They were called the railroad tax cases. And in each case, it was argued that because the Supreme Court did not use the word natural when they said person, that the railroads should be able to invoke personhood. They should be able to claim that they were people. And so essentially, and in this case was called Santa Clara County versus Southern Pacific Railroad. In this case, the railroad was saying because they pay a half a penny tax on every fence post along their rights-of-way in Santa Ana County, but a penny tax for every fence post along the rights-of-way in Santa Clara County, or Santa Ana County, Santa Clara versus Santa Ana, that is unequal protection, that is applying the law differently in 2 different places. And that was the equivalent of saying to a white person, you may sit at this lunch counter, but to a black person you cannot. And they took that case. They took several of these cases to the Supreme Court. The court basically laughed at them on several of them. Finally, in 1886, in the case of Santa Clara County versus Southern Pacific Railroad, the court ruled against them. But the Chief Justice, within a year and a half, was dead of congestive heart failure. His name was Morrison Remick Waite. And the clerk of the court, a fellow by the name of John Chandler Bancroft Davis, who was the son of the former governor of Massachusetts and one of the richest men on the East Coast, and the former president of the Baltimore and New York Railroad. The clerk of the court wrote a head note, which has no legal standing whatsoever. The head notes are like the cheat sheets. They're like the cliff notes for a Supreme Court decision. A head note that said, and I quote, "Corporations are persons under the law and entitled to equal protection under the law." End quote. It's right there in the head note. You can read it. You can go to supremecourt.gov and read it. But if you read the decision, you find that in the decision, it says the exact opposite. They actually ruled against the railroad. But the head note says that they ruled in favor of the railroad. 10 years later, the Supreme Court quoted the head note in another case, and that established legal precedence. The 1886 case didn't actually establish legal precedent, but when the court in the 1890s quoted John Chandler Bancroft Davis, quoted the head note, then, because if the court quotes Daffy Duck, it becomes precedent. It doesn't matter. That became precedent, and there have been 34 cases since then. In fact, in Boston versus Bellotti in the 1980s, and in that case where the state of Massachusetts said it's illegal for a corporation to give money to a ballot initiative or a candidate unless it's a ballot initiative that's specifically about that corporation. In that case, Rehnquist, who is, the conservative, the Chief Justice of the Supreme Court, Rehnquist, wrote in the opinion, in his dissent from that case, he was opposed to that case, even though it passed, and that was one of the things that makes it almost impossible to keep corporations now from giving money to politicians. In that Boston versus Blatty case, Rehnquist wrote, in 1886, this court ruled that corporations are persons, and I believe that was a mistaken ruling.
Yes.
And in fact, it never ruled that way. But that's where it started, Stan, and the Federalist Society, which came out of the 1971 memo that Lewis Powell wrote and gave to the chairman or the president of the American Chamber of Commerce, which led directly to the formation of the Heritage Foundation, the Cato Institute, and the Federalist Society. The Federalist Society was created to promote, in large part, to promote corporate personhood, the idea that corporations are persons. And so now we've had the Supreme Court rule in a case with Dow Chemical. Back in the 1980s, Dow Chemical was illegally emitting a toxin, I believe it was benzene, into the air. A whistleblower inside the company called the EPA. EPA flew a small plane over the top of Dow Chemical and said, look at this, we got pictures, we got proof. And they nailed him. Dow Chemical took it all the way to the Supreme Court and said our Fourth Amendment right to privacy was invaded because they did not have a search warrant when they flew that plane over our factory. Now, here's what's so ironic about it. If you go to and the Supreme Court said, okay, because of this 1886 case, you've got a Fourth Amendment right to privacy as a corporation. Nike claimed a First Amendment right to free speech as a corporation to lie, to publish news releases that said that they were not engaged in sweatshop labor when in fact they were. They took that all the way to the Supreme Court. Walmart claims a 14th Amendment right against discrimination whenever a community says we don't want a Walmart. So this all goes back to that case. It all goes back to corporate personhood. And it's absolutely bizarre that we would think that a corporation has the same rights as a human being and is protected by the Bill of Rights. It's absolutely bizarre. But now more than 50% of all the judges in the United States, here now 30 years later since Lewis Powell wrote that memo that laid out this whole vast right-wing conspiracy, vast corporatist conspiracy, and 3 months later was put on the Supreme Court by Richard Nixon, by the way. Ever since 71, when Powell wrote that memo, here we are now, 40-some-odd years later, or about 40 years later, and now more than half of all judges at the federal level are Federalist Society members dedicated to this. John Roberts, the Chief Justice of our Supreme Court, made his living as a lawyer, $2 million a year living, defending almost exclusively corporate personhood in corporate cases. So that's why, in answer to your question, that's why. And corporate personhood is one of the most toxic doctrines there is. The whole idea that a corporation which can live forever, which can clone itself 1,000 times, which can own others of its type, which can aggregate wealth forever, which can influence elections easily, which has power of life or death, that a corporation should have a level playing field with you and me over things like free speech or the Fourth Amendment right of privacy or the Fifth Amendment right to not speak against itself. The tobacco companies in the 1930s and the asbestos companies in the 1940s invoked their Fifth Amendment right to non-incrimination, to not reveal the toxicity of their products. And as a result of that, in the 1950s, when my dad went to work in 1953 at a tool and die shop in Lansing, Michigan, and worked there for 40 years and was exposed to asbestos in that workplace and died a god-awful death with me sitting there with my hand on his shoulder in his living room 2.5 years ago, puking up his own blood out of his own lungs because he got mesothelioma, which is a cancer which is only caused by exposure to asbestos. And that exposure was in the 1950s. The first published information about this in the American Medical Association Journal was in 1934. The asbestos companies in the 1940s and 50s invoked corporate personhood, their Fifth Amendment right to not testify against themselves, to not tell people and not tell workers what they were being exposed to. This is so wrong. You can see how this has devastated America. And it's one of the things that we really need to push back against. I wrote several of my books have chapters about this, and one of my books is entirely about it. It's called Unequal Protection, The Rise of Corporate Dominance and the Theft of Human Rights. Lays out the whole story. Reads like a thriller. You know, how we learned this, how it happened, how it all came about. The way to change it is either legislatively, which means we've got to tell our legislators, end corporate personhood and end it now, or through a Supreme Court ruling, through a really good, strong Supreme Court ruling. Without one or the other, we're going to have this forever, and it's going to be a disaster.
You're listening to the Thom Hartmann Program. Visit ThomHartmann.com for audio and video archives.